Virginia, this is actually, I have to say, this is probably going to be one of the most interesting programs we've had, and I think one of the most practical things.
You need to stay involved if you have vulnerable parents or relatives. Stay on top of these things.
Thanks be to God, it actually turned out okay. The appraiser and I, it was a miracle. It was one of those miracles in life. The appraiser and the broker agreed.
And then they decide they're going to move in with the parent, and then they start running up the parent's credit cards, and then they decide that the house should be sold and they're going to get the will changed.
It's really sad. It's actually really sad. Wow. I mean, it's almost soul crushing. That is very, very sad. So
it become a huge issue because they will go along with whatever they tell them, sometimes even being abused by them because they're terrified of losing the support and care of this one person who they think is the only person in the world that's going to take care of them.
It kind of comes in waves. It kind of comes in and out. It's not steady. They're kind of like borderline. The title officer is looking at me and I'm kind of looking at the title officer.
Family members do often take advantage of other family members.
But eventually we'll get there. And as we've been talking about this, I'm just thinking, wow, I hope my children, the people that I love, are thinking about me when we get there. So.
Well, let me tell you one thing. It gets pretty ugly. So you definitely want to avoid it, and it gets very expensive. It's almost like divorce court.
I'm definitely going to share this episode with people who come to me with this issue. So I wish, Virginia, we had met a year ago, because I've had a couple calls where I've had this issue. I've actually turned down business where I didn't feel comfortable. Welcome to the Texas Probate Real Estate Podcast. My name is Jeremy Kritt, owner and broker of Kritt Real Estate and the founder of Texas Probate Real Estate. This is a program where we bring to you leading professionals in the probate space. Today, I have Virginia Sampson. She is a very highly qualified attorney here in the greater Austin area. And today, we're going to talk about something very interesting. We're going to talk about dementia, Alzheimer's, mental health issues, and as it relates to law, probate, estate planning, and things that touch on this area. Virginia, I want to welcome you to the program today.
Thank you for having me, Jeremy. It's a pleasure to be here.
I have been really looking forward to this podcast because we're going to cover some issues that I got to tell you, Virginia, there are things that I have encountered in my practice as a real estate broker, and they're very touchy issues. And I got to be honest with you, a lot of real estate agents, brokers, people that are dealing with people with very important transactions like real estate. We're coming across people with dementia, with Alzheimer's, with certain mental health issues. And, sometimes it's a little bit tricky. And I know in my case, it's been a little bit scary at times. So I'm really looking forward to getting your expert opinion, guidance, and knowledge and experience on this matter. Before we get into our program today, I just want to have the audience get to know you a little bit. Can you tell us a little bit about where are you coming from? Where did you grow up? Where did you go to school? How did you get into law? How did you get into this area?
Okay. Well, actually, I grew up in Pittsburgh, Pennsylvania. I went to law school in Los Angeles, and I've practiced law in 4 states. So this is my final state on my law journey. I have so I started out primarily as a civil litigator. I did a lot of personal injury insurance defense, business litigation. And then when I came here, I was doing some of that as well. But then I lost my husband to Lou Gehrig's disease many years ago, and that kind of got me thinking about estate planning. And then when I moved here, my parents moved down from Pennsylvania to live near me because of my mom's health issues. And I got involved in helping them kind of navigate the aging process. My mom was diagnosed with dementia. And so as a result of helping them and some of their friends and neighbors, I realized there was a real need in this area for advice and some planning, right? How do you plan for the aging process? This applies also to people that unfortunately have a terminal illness. And, I feel bad. We're kind of doom and gloomers in this field. And lawyers, our job is to kind of always look at the worst case scenario. So maybe I feel like some of the conversation may be a little dark today, but we need to have that conversation. I find that it's a very difficult conversation to have with people. So anyway, that's how I got into this, was realizing that there's a need for a planning process, right? You need to see a professional who can talk to you about all the ins and outs of this and put together a comprehensive plan I typically like to get as many of the family members involved as possible so everybody's kind of on board. And, through my personal experience, I came to this to focus my practice on this area of the law.
That's really interesting. And, it's an area of law that is, I just don't hear a lot of people talking about it. We don't really, and it's hard to find people. I think this program is going to be great because when people are looking for someone in this specific area, when they're searching the internet, I'm hoping that they're going to find us here talking. Let's get right into it, Virginia. So I guess what we're talking about here really is mental capacity. And walk me through how to think about this. What is mental capacity? How does the law think about it? I'm all ears. I'm a total layman.
Okay, so I just heard on the news actually this morning that 1 in 9 people in the United States are diagnosed with some form of dementia or Alzheimer's. And of course, that number is going to increase as more and more people age. There's different, people who are listening to the podcast may be familiar with the criminal context where, we have a standard as to whether somebody is mentally competent to stand trial. And there's a lot of case law, and there's nothing really black and white in the law, but that's less gray than the area that we're going into, right? So we're going into estate planning and executing legal documents. Like, for example, with you, does somebody have the capacity to execute a contract for the sale of their property? And that becomes an issue of, typically in my situation, a dementia or Alzheimer's diagnosis. An Alzheimer's diagnosis or dementia diagnosis does not automatically preclude you from executing legal documents. It's a bit of a gray area, but it is very important, I would say, in this field, if you suspect that your spouse or your loved one is experiencing some memory issues, that you address that issue if you don't have some type of an estate plan in place, because if they get to the point where they become what we call incapacitated legally, then they're not going to be able to execute any legal documents. And then that becomes a whole separate issue.
Virginia, I want to get to a practical kind of aspect of this. So I'm thinking as a real estate broker, I'm frequently face to face with clients, potential clients. And I've had several situations where, let's say, the owner or whoever needs to execute these documents to make a real estate transaction happen, they'll have like a son or daughter, and they'll say something to me like, hey, she's just like not always with it, or, she's kind of in and out or something like that. And I always get confused in those situations because it's like, on the one hand, I'm thinking as a licensed professional, I have a high bar, to answer to if something goes wrong. And I'm like, okay, I feel uncomfortable kind of proceeding because it's like, okay, how do I evaluate whether this person really can do this and I don't have liability because I'm having someone feeble-minded, do a bunch of things that maybe is not best for them because I may not have the whole context, right? There may be a whole bunch of things happening in the background I don't know about. Walk me through, how should professionals like myself think about this situation? Because it's actually quite, as I'm thinking about it with you, it's quite common. I mean, I can think in my mind over the last trailing 12 months, I've had at least 3 or 4 of these situations where it's maybe like, especially with probate real estate, it's a surviving spouse, and they're older. And it's like, there's other people and they're like helping them, right? I assume that we're good faith. Obviously, I'm doing my own due diligence, I'm probing, but it's kind of confusing.
So the biggest risk, other than liability, and that involves attorneys too, because if we are going to have someone prepare estate planning documents, we need to feel that they're competent. And for us, the standard is, do we feel the person understands the nature of the document they are signing? Right. Somebody does not have to be lucid 24/7. At the time they're signing this document, they need to be able to understand the nature of the document. And we can go into that a little bit more. So if you suspect they're not, or if somebody later wants to challenge this, then they can challenge it on the basis that the person lacked the mental capacity to execute this document, which means it can be challenged in court. And I guess potentially the whole thing can be undone, because if they lack the capacity, then it's not a valid contract. It's not a valid legal document at all. So what I say to clients is that if you suspect that if there's really a lot at issue, you can take your loved one, and I know this is not something people want to do, but even internist general practitioners can administer a test. Typically, what I see is administered is called this MOCA test, which is basically just a screening test. It's just a series of questions. And then if the medical practitioner feels there might be an issue, then they can refer him or her on for more screening. And the reason I say go to their family doctor is because that's less threatening to a person than saying, hey, I'm going to take you to a neurologist because, I think that you're not mentally competent. This can be just part of like a normal, annual exam that you could have administered. So that's one way to feel comfortable. If they pass that test, and there's no gold standard, right? I mean, this is the law. People can challenge anything, but that's certainly some comfort to you as a professional and to family members who are maybe assisting the loved one to know that, yes, this person, at least medically so far, has been determined to have a legal capacity. Now, obviously, we know dementia can change rather quickly. But that's some comfort. At least that's the first step, I would say, to determine the capacity of the person.
Yeah. One of the things I find really interesting is, as a non-medical person, is that dementia and, Alzheimer's, as it presents in individuals, it kind of comes in waves. It kind of comes in and out. It's not steady. And so I've had situations where, we've gone through the whole transaction. We're now at the table, closing table. And all of a sudden, it's like they're kind of like borderline. And, the title officer is looking at me and I'm kind of looking at the title officer. And I'm just like, okay, I've been through this whole transaction and, I feel comfortable that they kind of know what's going on. But in that moment, they're not quite sure. And they have to sell, right? These are situations where they have a situation where they need to sell. They need the money. I think everyone feels like we're doing the right thing. But in that moment, it's not clear, it's not totally clear cut. My personal approach has been to, get to know the family members a little bit more, try to understand like who's in the network there that kind of has been taking care. But sometimes, I get a little worried sometimes because I'm like, you don't know what their motivations are. It's very, very tricky. It's very tricky. I'm curious, Virginia, you're a very experienced attorney. You've been around the block more than once here. You know what's going on. I'm just curious, in your own experience, what are some experiences you've had with this where you were like, well, yeah, I'm not sure, or maybe had to do a little bit more due diligence? Have you had anything like that recently, or a case that you remember?
Yes. And I would say one of the family members do often take advantage of other family members. In my experience, that's pretty much, seniors are getting scammed by, phone calls or solicitations, but a lot of what is happening is one family member taking advantage of their elderly parent. And so you do need to be careful because you really don't know what people's motivations are. That's why sometimes getting all of the family involved helps. If you're talking to all of the children or siblings of the person, then you can kind of, feel more comfortable about the process. Yes, I have had situations, one recently, where people live out of state and then one child lives here and then they decide they're going to move in with the parent and then they start running up the parent's credit cards and then they decide that the house should be sold and they're going to get the will changed. I have a case right now where it's in litigation where the child that moved in with the dad, the house was supposed to be sold to pay for assisted living for him, and they didn't want to have to move out, so they cut their dad off from contact with everybody else in the family and went and had the will changed.
Wow.
Yeah, so it happens, and we are in some big litigation over that right now.
Okay. Wow.
As to whether he was competent at the time to actually execute a new will. So
Okay.
yes, it does happen. That's what will contests are about. That's what, guardianship are contested as well. But will contests for sure. One of the issues is typically, did the person have the mental capacity to execute a will? Was there undue influence? Was there fraud? Those are some of the issues you can raise if someone has a person execute a will later in life when they may have some mental challenges.
So, Virginia, I think one of the greatest insights you can bring to us on the program is because, someone like me, someone who's listening, someone who's going through probate, someone going through this situation, they may not have the legal perspective. So you're a legal expert and you're involved in litigation. So bring us into the courtroom. Put on your lawyer cap for us. Let's say you're challenging it, right? What are you doing? What are you looking for? What are the arguments you're making?
Well, let me tell you one thing. It gets pretty ugly. So you definitely want to avoid it, and it gets very expensive. It's almost like divorce court because you actually have family members pitted against each other, and it's kind of interesting. I see, as a practical matter, some of the issues from sibling rivalry kind of just pop up into the context of this courtroom. Sometimes you feel like you're back when they were like 15, right? All these unresolved issues between the siblings or siblings versus dad, they kind of can get played out in the courtroom. Those are primary the grounds on which a will can be challenged is the person lacked mental capacity to execute a will, and there's a certain law on that issue. Somebody exerted undue influence on them to get them to execute a new will, and then fraud, which kind of goes along with undue influence. So those are kind of your grounds. And if you're doing lack of mental capacity, typically that requires an expert witness, a medical doctor, which is expensive. They have to review medical records, they give you an opinion, and often they have to come to testify if the matter doesn't get settled. And then on the others, it's just a matter of, presenting evidence as to how a person has tried to influence the person who executed the will by isolating them. And if someone is isolating a family member, that's a red flag that something's going on. So if they're denying access to other family members, if the only information is coming from this family member, I would say that's a red flag that you need to explore more. And that's part of undue influence, is isolating them. Because what happens with people, especially with dementia, they become very frail mentally, right? And so this person inserts themselves as their kind of hero, their savior. They're the only one that can take care of them. So even if this person is lucid at times, they're terrified of alienating their caregiver, right? Who may be telling them, nobody else cares about you. I'm the only one who cares about you. I'm the only one who's going to take care of you. Or if no one else is coming over, they just presume that no one else cares, right? Even though maybe this person who's taking care of them is forbidding everybody else from coming over. So they become very susceptible to whatever this person who is their quote caregiver is telling them. And it become a huge issue because they will go along with whatever they tell them, sometimes even being abused by them because they're terrified of losing the support and care of this one person who they think is the only person in the world that's going to take care of them.
That's really sad.
That's
actually really sad. Wow. I mean, it's almost soul crushing. That is very, very sad. So I'm kind of curious, okay, how do we prevent this from happening to us? So, okay, so let's look at it from an estate planning side. So I'm looking at the future. I may become, I might start losing my powers, my mental faculties as I'm getting older. Let's just say I'm a very conscientious person. I'm thinking about that potential eventuality. What can someone do to protect themselves from being in this kind of situation?
Well, I would say everyone should have an estate plan, a basic estate plan. And especially as you get older, even without a diagnosis of dementia. And one of the reasons I say that is if your parents are getting older, or if you think your spouse or your loved one is they're aging, it's much easier to get a person to do the requisite documents if they're not already ill. And that means frail, right? So because part of the issue with executing these estate planning documents is you are giving some control over your life to someone else. And as we age, and especially if you have any level of dementia, you can be a little paranoid. You start to think, what is their motivation? I don't want to give control up of my life. You're already feeling like your life you're losing control of it. And then this person comes in and puts a bunch of legal documents in front of you and said, oh, now give me control of your finances, your healthcare decisions. And you're like, whoa, stop. So it's much easier to do that before they are frail or sick or pretty old. They're more likely to cooperate. And it's more likely they're going to get on board with it. You might even get them to take the initiative. I find with family members, if they approach their parents or their loved ones, sometimes, there's a resistance. But if you can get a professional involved and just say, hey, I think you should talk to a lawyer about, what do you need to do? And let the lawyer talk to them. I find that's more successful, less threatening to the person than a family member coming and say, oh, I want to be appointed your agent or I want to make decisions for you. That can be very threatening to an older person.
Yeah, for sure. For sure. I want to bring us to real estate for a moment. And I want to pose something to you. And then because this is actually something that I actually am not, I really think I'm going to learn something. I think the people listening to this are going to learn something. I've had some situations, Virginia, where I've been approached and basically it's very obvious that they're not able, like they have real estate They don't have any planning in place. There's no power of attorney or anything like this in place, and they have to sell. They're in a situation where they've got to sell. They need the money, but this person can't perform. So what do we do? What do we do in that situation?
So if you don't have an estate plan, and what I was thinking about is that is as part of the estate plan, you would have your parent, your loved one execute. I recommend a series of 5 critical documents, but for purposes of real estate, it would be a statutory durable power of attorney. You are empowering another person to make financial decisions for you. That can be a very broad power of attorney document, or it can be more narrow. That empowers the person designated to, sell the real estate, sign the deed, do those kinds of things. Now, again, the person who executes the document and appoints this agent has to be mentally competent to make that decision and know what they are doing. If that point has passed, then your only option is a guardianship.
That's what I want to get into. That's what I want to get into. Tell me about guardianship. So we have no plan in place. We've got let's say we're more advanced stages of dementia or Alzheimer's. Walk me through the guardianship process. What is it? Who needs it? How do we get it? How is it played out?
Okay. So in order to start an application, at least in Travis County, it's different in Hayes County and Williamson County, but in Travis County, you have to have a medical report from a doctor that says the person is incapacitated. That has to be filed along with your application for guardianship. So you do need to contact attorney because people cannot, what we call in the law, pro se. You can't file a guardianship application for your parent or your loved one on your own. You have to have an attorney do that. So you need to reach out to an attorney, and then the attorney will guide you through the process. But the first thing in Travis County is you have to have a medical report from a doctor that says the person that you're seeking guardianship for is incapacitated. There's a specific form the courts require to be completed and filed along with the application.
Virginia, so I want to backtrack 1 second. So we've got, let's say, daughter, okay, looking after her mom. That would be a very typical situation. Mom is not doing well. We have the caretaker daughter. Mom's not doing well. There's some real estate here. It's got to get sold, maybe for care for mom. She comes to me. I look at her. I'm like, oh, well, she can't sign this. Do you have a power of attorney? No power of attorney. Okay. I'm looking at her. It's clear to me she can't do anything. I go, well, you know what? You're going to have to go see Virginia. So I'm going to, because you're an expert in this. And now I've got my attorney for this. Okay. So I'm going to send him to Virginia. I'm going, hey, look, you got to talk to Virginia. She's the best in this area. She knows what she's doing. They go to you. You're going to say, okay, first you're going to lead them to go see a doctor to get this evaluation. Is that the first step?
Yes, if they already do not have a doctor. And typically that requires a neurologist. You can have a family practice medicine doctor do it, but sometimes they're hesitant to complete the form because they may not have the expertise. But yes, you do need to see typically a neurologist.
Got it. So we get the medical report. They come back to you. It's clear that, they don't have the mental capacity to do what they need to do. What's next?
So then you prepare an application. Somebody has to decide to be the applicant. I don't know if that's the daughter who's the caregiver. We prepare an application. It gets filed at the court. We have to give notice to all of the adult children, any siblings. Not likely parents are alive, but there's certainly family members that have to have notice of the proceeding. And then someone can contest it. I do have contested guardianships. So somebody can say, they can file a cross application, say, no, I want to be the guardian, or I think this person isn't qualified. If it's not contested, it's a fairly simple process. If it's contested, it can obviously drag out a lot longer. If you are going to be the applicant for guardianship, you are required to take an online training. And you do have to have a criminal background check done.
Okay, that's very interesting. I want to back up a little bit. You said some things that were very interesting to me. So when you make this application in the court, other people have to be notified. Is there a standard? Like, is it all next of kin? Is it all like who? Like, how do you determine who gets notified?
It's set out in the statutes.
Okay, so it's in the law.
Statutory requirement as to who is notified.
Okay, got it. So everyone's notified. Walk me through some of I think this is the benefit of having such an experienced attorney as yourself. So walk me through some of these contests regarding guardianship. What have you seen played out? What are some interesting observations that you have regarding that?
First of all, let me say there's two different, you can be guardian of the person and guardian of the estate. So obviously the person makes decisions as to where what we call the ward, that's the name for the person who has a guardian appointed, would live, makes healthcare decisions, and then guardian of the state obviously manages their finances. They don't have to be the same person.
Okay.
We do not allow co-guardians in the state of Texas for older people. So the contests involve sibling rivalries, right? One child applies to be the applicant, the guardian, and the other child says, no, I don't think you're qualified. And then they're off to the races trying to prove how the other person isn't qualified. They've taken money from their mom. They don't have their mom's best interests at heart. Those types of things. So,
Wow.
yeah.
And I imagine I'm thinking of like $400, $500 an hour or more racking up. So this is a very expensive process. I'm assuming like this happens usually when there's more money involved, or have you seen it play out with people that with lesser means and it just becomes a huge financial kind of nightmare for the people involved?
Have seen it happen with people with less financial means. They don't, sadly, I have one of those going on right now. They don't necessarily have the funds to hire an attorney, but they start influencing the parent who you want to have appointed. Again, isolating, saying, my sister does not have your best interests at heart. Getting the mother to go to court and say she doesn't want this person as her guardian. She wants the one that's influencing her. So there's ways to do it without hiring an attorney, kind of insidious ways. But if there is more, obviously, finances involved or people, then people typically have an attorney do that. But it's not impossible to do it when you don't have the funds for an attorney. It gets, I have one of those going on right now.
That's very interesting. What happens if you don't have, because the first thought that we have is that it's going to be a family member, right? Probably a son, daughter,
Yes.
close relative. But I imagine there are some people where either they don't have a qualified relative or they don't have any close, like they don't have any close associations that can fulfill this role. What happens then?
So there are some private professional guardians in the Central Texas area. And if you are indigent, so say, no one really has any funds to pay to have a guardian appointed, but somebody needs to be appointed the guardian. There's a letter, and it's in Travis County, it's on their website, where you can say you are an interested party and you submit it to the court, and then the court appoints an investigator. And then if they feel the person needs a guardian, then they have people on a list who will serve as a guardian for the person for a nominal fee, or they're paid by the county. We have family elder care, which provides free guardian services to seniors. They usually don't have a lot of availability, so they're so busy. But there are some free services available, and then there's some private paid ones that just charge various amounts to manage the person and the estate.
Would you say that's relatively common, or is it uncommon? Let's say just Travis County. Is there quite a large number, or is it fairly rare?
You're saying about professional guardians?
Yes.
I'd say it's pretty rare. Usually there's a family member that's available. So I have one going on right now. It's because there's no really close family member available. Because, they do charge a fee. And if it's not a large estate, that can be expensive. So typically family members will step forward to be the guardian, and it is unusual to have someone else. Sometimes, like one of the very contentious guardianship cases I had, we did have to get a third-party guardian because nobody could get along with each other and work anything out. So the court just appointed a third-party guardian.
Now, you as the attorney, do you have any say on who that guardian is, or is it just the court will choose from a list that they have?
Well, you can suggest someone, but it is ultimately the decision of the court. And that goes for any family member, too. I mean, the judge will make the final decision as to who will be appointed guardian and what their powers will be. The judge can limit the powers for the guardian. Typically, they don't. I've noticed that doctors lately will say on their report that they don't want to take the ability of the person to vote away. So that's considered limiting the powers. But typically, if you're in the guardianship stage, the court's going to give the guardian full power based on whatever the doctor says in their report. They pretty much follow that. It's a specific report that tells the doctor tells the court and the parties what this person is capable of doing and not doing, and there's certain boxes they check. So the court will follow that a lot, and giving the guardian full powers or limiting their powers to a certain extent.
Have you had people fight the guardianship? So the person that's going to be watched over, they're fighting it. I suppose they're
Yeah.
there because they're limited power, they're diminishing capacity. But I'm thinking of the older people in my life over the course of the years. Like some people go into docility. Some people are fighters, as
Yeah.
they get older. So how does that work?
So in a guardianship proceeding, the court automatically appoints what we call an attorney ad litem who represents what we call the ward, right? The person who you're seeking to have a guardian appointed for. And they're appointed off of a list that the court has. You have to qualify for that to be on that list. And then the court just randomly picks someone, the next person on the list, to be the attorney ad litem. And so, yes, they are represented. And yes, they very often do contest. And a lot of that just depends on who the attorney ad litem is. I mean, some of them believe that it's even if the person's incapacitated, they have to follow their wishes. And even if it's not in the person's best interest, I don't know that I'm on board with that. But and others will take the position. So here's what happens. The ward says, oh, I want my son so-and-so to be the guardian. Well, the son has obviously not been acting in the parent's best interest for quite a long period of time. So sometimes the attorney ad litem will say, oh, yes, this is who my client wants, and they'll put that forward, even though it's not in their client's best interest. And then other attorneys take the position that it's not in my client's best interest and they're incapacitated, so I'm not going to put that forward. So it just depends on who the attorney ad litem is. The court has the ability to appoint a guardian ad litem. They are assigned to investigate the situation and report back to the court about what is in the ward's best interest. Now, again, they're expensive, right? They're usually attorneys. The court can also appoint a temporary guardian. So in the situation you were talking about where this property has got to be sold and, being appointed guardian, even if it's not contested, is going to take a period of time, maybe 3 months, 6 months. They can appoint a temporary guardian and give them some powers to maybe, sign the deed and then until the final guardian is appointed. So they act in interim. They're the interim guardian until the court appoints a guardian at the finality of the proceeding.
I love how the law is structured so that it's trying to protect the person. Like there's it's almost like a devil's advocate kind of thing.
Yes.
And I think that's really cool. It's obviously very thought through, and it's actually comforting to know that that process exists. Walk me through now, let's say the guardianship, it's gone through. The person has a guardian over them. Is it just basically now, is there any checks on that person as they're going through? Is anyone checking to make sure that something's, not gone off the rails or something? Or is it just that once they've been appointed as guardian, they're just basically, they've been vetted, they're trusted, and it's just like the process has kind of worked and it's unlikely that something nefarious or bad would happen after that?
Well, not necessarily. They do have to post a bond.
Okay.
If you're guardian of the person, that's at least an $18,000 bond. And
Wow.
then they have to post a bond if they're guardian of the estate, which is tied to the value of the assets of the estate. Annually, 1 year from the date of their appointment, they have to file a report of the condition of the ward. Where are they living? How are they doing? And then they also have to file an annual account with the court. Obviously, if someone senses something's going on, they do have court investigators that they could, bring this to the attention of the court and have an investigator go out. I haven't been in that situation, but they do have court investigators that go out and visit people and make recommendations to the judge. So if somebody thinks there's something going on, certainly they could report that to the court and ask that it be investigated.
In Travis County, that's all done through the probate court? Is that correct?
Yes.
Okay.
Yes.
So Judge Herman and who's the other? There's the other judge.
Chu was appointed about 2.5 years ago.
Got it.
So we have a statutory probate court here in Travis County, but if you go to Williamson County, you're in the county court. You're assigned to Judge McMasters, who's courtroom number 4, because, a lot of the counties don't have a large enough population of a statutory probate court. We just added an extra judge because we have so many cases here, but a lot of the smaller counties around us do not have statutory probate courts. It doesn't really matter, but like if you go to Williamson County, Judge McMasters as the county court hears divorces and all kinds of things. It's just not limited to probate.
I'm just curious, is there an advantage to having a statutory court versus a court that's hearing all kinds of things? Does it add anything? Does it matter? Just from a kind of efficiency perspective.
No, I think it more depends on how busy the court is, right? And the number of cases on their docket. can be an issue. And, Travis County is pretty busy, so they have a very busy docket. I don't really think, Judge McMasters is sadly retiring at the end of this year, and he has so much experience that he can easily change from family to criminal to probate. Now, I don't know what the experience of the new judge has. So I don't think that's affected the quality of the decisions that you get so far because of his experience.
So this is Texas Probate Real Estate Podcast, and let's focus on real estate. With these matters, with like guardianship, is real estate part of the picture most of the time? How does real estate play into these matters in your experience?
Yeah, typically most people have some real estate that becomes part of the estate that the guardian manages. And that can include having it sold. Typically, if the ward goes to live in an assisted living community, then obviously the guardian has to apply. You have to do an application to the court to get permission to sell the property. And that's where you would become involved. So the lawyer files the application. A realtor does have to come to court and testify about the value, the listing agreement, and then the sale has to be approved by the court also. So it's a little bit of a process. It doesn't the guardian just can't go out and sell the property.
I haven't yet been called into court to talk about my real estate transactions. I'm sure it's going to happen eventually. The majority of the real estate I sell is part of an independent administration. That's like by far the most common. I do have a situation right now where it is a dependent administration, but there's a very urgent matter because the property is basically in pre-foreclosure, and the court gave basically like an emergency order to yes, you have permission to sell this now and do it. And so maybe that'll be a situation where we it'll have to be reviewed by the court and whatnot. Interestingly, I was actually worried in this situation because, obviously the court ordered an appraisal, which is fine. But, sometimes these appraisals, brokers and appraisers don't always agree on things. So sometimes, you have an appraised value and it's like, okay, yeah, they had a methodology, right? An objective methodology to arrive at their number. But there's a lot of subjective judgments that go into, the inputs. Okay. And so in this situation, I was kind of worried because I'm like, okay, this is a dependent administration. I know that the court is, this is subject to maybe greater scrutiny. So, and I run a pretty tight ship, Virginia. I run a very tight ship, actually. I try to run a very compliant file and, things are defensible. But, it's a little bit different when you're thinking, okay, I might have to go talk about what we've done here. And I was really worried because I was like, okay, we need to make some money, but we also need to sell quickly, and I was worried because, the property has all these kinds of defects, latent defects in the property, and a lot of things are going on with this property. I mean, hole in the roof. I mean, it's in a nice neighborhood, but it's been, vacant for a while, et cetera. And we had this appraisal done, and I told my client, I said, this appraisal may differ significantly from what I think this will need to be listed at in order to sell it in the way that we need to sell it. Thanks be to God. It actually turned out okay. The appraiser and it was a miracle. It was one of those miracles in life. The appraiser and the broker agreed, and I think it's going to be okay. But it's interesting. I haven't yet had to go to talk to a judge about, okay, this is what we did. What does that look like? Can you prepare me, Virginia? How does that look like? What do I need to do?
Well, first of all, so let me explain a little bit about probate because people don't really understand what that is. So guardianship is obviously a proceeding while the person's still alive, right? Probate is after the person is deceased. And probate involves taking the will, having the court declare that as the last will and testament, and then appointing an executor who then gathers up the assets, pays the debts, and then distributes to the beneficiaries designated in the will. If there's not a will, you go through an intestate proceeding where the court determines who the heirs are, which is determined by statute. And then a person is appointed the administrator, and then they do the same thing. Yes, in an independent administration, and that's one where there's no court oversight. And typically when I prepare a will, I make it independent administration. a lot of it depends on the dynamics of the family and the value of the estate, whether you want a lot of court oversight or not over court oversight. But typically, as you were talking about, the executor can just put the house up for sale or the property up for sale and sell it. But yes, independent, the court wants, they're going to manage the sale process of the assets and make sure it's sold for a fair price. They have to approve the sale, kind of just like you would do in a guardianship. So typically what I do if I bring a realtor is that they talk about their credentials, their background, right? They talk about, what they've done to research the value of the house, looked at the comps, and then they tell the judge how they've come up with this value. And usually in my case, in the guardianship cases, the judge will set a range, right, of value for the house. And then the court will approve that it be sold at this range. So they don't usually specifically pick a dollar amount. They do a range because, they realize that real estate is, no one's going to offer you exactly the amount. So that's kind of what you do. Yeah, it's based about what your experience is and what research you have done to determine the value of the property.
Yeah, got it. But do realtors sometimes have to go into a courtroom to talk to the judge about? Okay. Walk me through. That's actually very interesting to me. What does that look like? I don't think I want to experience that, but I'm just kind of curious. I'm sure it's going to happen someday. So what does that look like?
Yeah, sometimes if you do, like in a probate, if you do an appraisal, the judge will usually just look at that. But like in a guardianship, appraisals are expensive. So sometimes the judge will say, well, we will forego the appraiser. Let's just have a realtor come in. It's like anything else. They get sworn in. So a party calls them. And so if you are filed the application to sell the property in a guardianship, you call the realtor. They sworn in. They're on the stand. You ask them questions about their background, their experience as a realtor, their knowledge of whatever the market may be, the Travis County market. And then you ask them questions about how did you arrive at a value for this, and how did you arrive at that value? And then they'll go through all the comps. Sometimes they'll have a written report that they can refer to. I haven't really had the judge want to have that admitted into evidence, but, they'll have done some research, and then they'll tell the judge, I think the value is between this amount and this amount. And if the judge feels confident in the credentials and the research done by the realtor, then they will enter an order that the property can be sold within that range. Now, that's not to say you can't. In this market's different. So if it doesn't come in at that amount, then you just have to go in and get the permission of the court to sell it for a less amount.
Yeah. In the real estate world, we have something called a broker price opinion, which is a little bit different from, it's funny, in the actual rules, the TREC rules, they talk about a CMA and a broker price opinion. In a more colloquial kind of understanding, a CMA is a little bit less formal. Sometimes when you go see a client, you just kind of like, this is kind of what the market looks like, kind of more generally. And, so you're giving kind of knowledge to the prospect about what the conditions look like, what things around have sold for. And then you might together come up with a value that you will list the property for. Obviously, you're going to give a range and a price that you think it should sell for. But a broker price opinion is a little bit more involved. I've done actual formal broker price opinions for asset management companies where maybe it's getting close to pre-foreclosure or it's starting to become delinquent. And so it's a more formal report with where you're showing the adjustments that you're making for value. And you're giving more of a narrative of kind of the market conditions. Is it going down? Is it going up? Things like that. I have more recently got into the habit of actually doing broker price opinions for properties that I'm selling in probate because it's a much more extensive report that, kind of survives. So it's like, so that way when it's, when the sale is done, it's not just like, oh, here are the comps. It's more expansive. It's like, okay, these are what houses have sold for, but also these are maybe active competition of homes that are for sale now, more narrative about the market, more kind of expert opinion on kind of what you think about it. So I've got more in the habit of doing that, especially with probate real estate, because I think the attorneys appreciate it. There's a kind of value report that an agent can do, but it's not, the Texas Real Estate Commission is very clear when we provide a CMA or broker price opinion, it does have to have, very clearly a disclaimer that says this is not an appraisal, it's not the same as a value that's come up by the principals of the, I forget the name of the organization, but whatever the main organization, the main body, it's not to the same methodology as that. But I would say for an experienced broker, not a new agent, because a new agent doesn't really, I mean, when I was a new agent, thank God I got through that stage, okay? Because, you make mistakes when you're a younger agent. But, for a more experienced agent broker, you've done hundreds of, like, for example, for myself at this point, I've done hundreds of transactions, all over the area. So you have that experience, but also you have the data available to you, and you can be more precise and more close to what's actually going on. Let me ask you this. I mean, so, as an attorney, I'm sure that if there was a broker price opinion that was part of that file, that would be very useful. Are there times that you felt like, man, you wish you had that, or you didn't have it, but you wish you had a report like that? What are you for?
I'm all for the best information available. I think it protects me, it protects the broker, and I think it makes the judge feel more confident. Right. I mean, everybody wants as much information and as much reliable information as possible. So I'm all for the most reliable information. I think it's worth the extra time and expense to produce that information.
Have you had any issues regarding real estate sales in these situations, whether guardianship or probate, where, there was a dispute or something that was going on specifically related to the real estate, and any potential lessons that could be learned from that?
Really, because typically people will argue about the real estate transaction before an order is entered. So
Okay.
typically once an order is entered, you can appeal that order. Like, for example, if you feel like the judge would just totally miss the mark, obviously you can take that to the Court of Appeals.
Mhm.
But most of what happens in that situation happens in the hearing on the application for sale of the property, when you might have competing values or, those types of things, that the judge then makes the decision as to what he thinks the value of the property is. And again, that can be appealed. But so once it's the judge orders, that's given unless you appeal it.
Okay. Got it. Well, we have been here for almost an hour, believe it or not. We've really covered a lot of ground. Virginia, this is actually, I have to say, this is probably going to be one of the most interesting programs we've had, and I think one of the most practical things, because I know that as someone who sells real estate, it's interesting. Real estate's very personal, especially something like probate real estate. That's what I call it. I call it probate real estate.
That's a good term for it. Yeah.
Thank you. Okay. Thank you for that validation. I appreciate that. And, there's all these sticky situations, and it's interesting. You get into these situations and either it's before you're contemplating the business relationship, or you're already in a listing agreement with someone and you're in process and things happen. And like this issue, this comes up, especially with probate. People are typically older. Maybe it's a surviving spouse. Maybe it's older children. And this issue comes up. And I'll have to say, when we're getting our real estate license, this is not something we really talk about very much. I do think, though, that the licensing law for real estate is very wise in the sense that, they don't just let a brand new licensee just go off and be a lone ranger. You have to be supervised by a broker who, hopefully, not always, I would say, but hopefully they have a little bit more experience, a little bit more knowledge, a little bit more, as I like to say, common sense, which is often lacking in the real estate industry. But to go through these issues in great depth, I can tell you just from my perspective, very, very valuable. This has been very valuable information. And there's a lot of things I've learned here that I can take on and use in my own real estate business. And I hope maybe other agents can learn from it as well. I'm definitely going to share this episode with people who come to me with this issue. So I wish, Virginia, we had met a year ago, because I've had a couple calls where I've had this issue. I've actually turned down business where I didn't feel comfortable. So I feel like with this, there is a pathway. We can send them to Virginia. We have a pathway to a solution, which is important, because sometimes without that information, we don't know the right pathway. So maybe we can't do business right now, but hey, here are some things you can do so that I can get into the position to be able to help you, right?
Yes. And one thing I want to touch on that you had alluded to a couple of times is the statutory durable power of attorney document that authorizes the person designated to sell real estate. So that's what you would look to, right? If we don't have a guardianship, that's kind of the step before a guardianship. And that's one of the documents. I said I recommend 5, but that's one of the documents can help you avoid guardianship.
Okay.
The downside of that is that there is no court oversight of what happens to the proceeds, right? The person named as the agent has a fiduciary duty to the client, to the person named in the durable power of attorney who's giving them the power. Unlike a guardianship where there is more oversight, but that can empower people to sell real estate. But please be aware, if you are a family member, that somebody with not the best motives can have the person execute a new statutory durable power of attorney revoking that. So you need to stay involved if you have vulnerable parents or relatives. Stay on top of these things. I would suggest just don't abdicate it to one member of the family.
Excellent advice. Excellent advice. I guess we hope that eventually when we get to this point that the people around us will actually really care about us and do the right thing. A lot of this depends on, as I'm thinking about it, I mean, thank God, you're sharp as can be. And hopefully I am as well at this point, but eventually we'll get there. And, as we've been talking about this, I'm just thinking, wow, I hope my children, the people that I love, are thinking about me when we get there. So this has been a great episode. Well,
I didn't want to be too doom and gloom. Most families do work together.
Yes.
It is unusual for this, but I'm just saying, remember the red flags. And
absolutely,
you get an estate plan in place for your vulnerable adult before it becomes too late for them to do it. That will save you a lot of stress and attorney's fees. And it gives them more control over their life, which they like.
Virginia, before we go, we want to always promote our guests. We want people to come to you and to seek your services that you've really demonstrated here so clearly. How can people get in touch with you?
I have a website. My email is just my name, virginiasampsonlaw@gmail. I have an office number, 512-980-4610. And I also have a website, Virginia Sampson. If you just plug in Virginia Sampson, my website should pop up, and you can contact me through the website. You can find a little bit more about me on the website.
That's fantastic. And I want you to know that we're going to have all of your contact information in the show notes. And if anyone needs to get in touch with Virginia, if you're having a hard time, I got the bat phone to call her. So just get in touch with me. I'll put you right in touch with Virginia. Virginia, thanks again so much for joining us on this program. My name is Jeremy Kritt, owner and broker of Kritt Real Estate and the founder of Texas Probate Real Estate. If you are going through probate and you have real estate to sell, don't sell your house at a discount to investors that may be calling you. Give me a call. I'll help you. I'll walk you through the process. I'll go through your options, even if that's not with me, and we'll help you make the right decision. My name's Jeremy Kritt. I look forward to meeting you on the next one.